Welcome to the top 12 highlights from Chapter 16. I'm Mr. Rodman, here to take you through civil rights and looking at the top 12 highlights from Chapter 16. Let's start off with the origins of civil rights, and you definitely want to take a closer look at the videos that I shared on Google Classroom related to the century, America's time, because that really gives you a good overview of the civil rights movement in America during the 1960s. And as a result of what we're going to talk about here, we're not going to talk about the historical aspects as much as we are the application to government. So hopefully you're able to take a look at those clips, and that will give you a much better orientation as to what we're talking about here. We start with Dr. Magleby in the book talking about the requirements for citizenship, this idea of birthright citizenship conferred by the 14th Amendment, as well as naturalization in terms of the requirements of what a person needs to do in order to be a naturalized citizen, and you see those outlined here. Let's start by talking about where the civil rights movement came from, and it really started as obviously as a result of the end of the Civil War. We had Reconstruction in the South that was basically trying to hold leaders in the South and elections in the South accountable for their actions to make sure that black men had the right to vote per the 15th Amendment, that slavery was abolished, and that the Equal Protection Clause was applied. Now we know that application of that, much of that ended in 1877 with Reconstruction ending as a result of the election of Rutherford B. Hayes. He would win the Electoral College, even though Samuel Tilden would win the popular vote, much to what we talked about in class about the Al Gore Bush election in 2000, and also in Donald Trump winning the Electoral College over Hillary Clinton winning the popular vote here in 2016. But the same thing happened in 1876, and with that, Rutherford B. Hayes agreed to end Reconstruction in the South, pulling out the military in terms of that enforcement mechanism, which basically pulled the rug out from underneath any type of Reconstruction efforts, which gave way to Jim Crow laws and black codes coming back into being. And it essentially was resuming the power structure that was in the South at the time. And the North, many of the political leaders, and obviously President Hayes, did nothing in terms of stopping that. So essentially, it allowed the South to continue the problems that they had with these Jim Crow laws and discrimination throughout the South and the southern states. And this went on. We saw Plessy v. Ferguson happening in 1896, basically saying segregation was the law and it was constitutional, and it would take until 1954, 58 years later, for the court to reverse that decision in a unanimous opinion. So the wheels of justice turn slowly, but they do turn. Unfortunately, it just took a really long time to make that happen. So we did start to see African Americans asserting rights in the 1930s. President Truman, at the end of the war, really tried to desegregate, by executive order, desegregated the military in 1948. We would see the Brown decision in 1954, Rosa Parks then coming in 1955, which would launch the Montgomery bus boycott. So a number of things that led to some civil rights victories. Unfortunately, we had in 1963, we had the assassination of President Kennedy. This would be after the March on Washington, in which Dr. Martin Luther King would give his I Have a Dream speech. Kennedy outlined the importance of a civil rights agenda, and then in November, his life was cut short in that assassination in Dallas. So leading the charge then would be Vice President Johnson, who then becomes President Johnson, and he says, "Hey, let's enact a legacy of the vision that Kennedy had by passing this civil rights bill, and let's not just pass another civil rights bill, because let's be clear, between the end of the Civil War and 1964, there were many civil rights bills that were passed. The problem was they didn't have any teeth; they were all watered down, and so the Kennedy assassination really provided President Johnson Johnson with the opportunity to say, let's focus on what we can do to pass this with teeth and with some momentum to be able to enact some civil rights legislation across the country. And that was really the significant part. Now, also, Johnson, being the former majority leader in the Senate, one of the actually the youngest majority leader in the Senate, he really knew how to get things done on Capitol Hill, and the legislative morass that was the slow-moving process of Capitol Hill, how a bill becomes a law legislation. But it really came in handy here in terms of trying to pass that. So he sits down with Dr. King and other leaders of the civil rights movement, and really focuses on how we're going to get these legislative victories, and really gets Congress to pass it, and he signs it into law, the Civil Rights Act of 1964, which is just momentous legislation in passing non-discrimination legislation and being able to enforce it. Now, there were some loopholes, there were some problems. Obviously, what you're seeing here is the Selma to Montgomery March, which leads to what we call Bloody Sunday, and President Johnson is watching this along with millions of other Americans on television. Now, television is bringing to us in real time the discrimination that is happening across the country in the South, particularly, and this at the Edmund Pettus Bridge is one of those events in which we clearly see that the law is not protecting black voters and African Americans at the time. And so this prompts President Johnson to call for a joint session of Congress. He addresses them, and he uses many words from Dr. King's speech, saying we shall overcome, and calls for a Voting Rights Act the following year to close the loopholes in calling for a 24th Amendment to ban poll taxes, to ban literacy tests, to really cut down on the violence against blacks that's happening at the time, and this is the first time a president addresses Congress in doing so, and he really takes a stand in this, being a Southern Democrat that's really taking a stand for civil rights, and is able to get Congress to pass the Voting Rights Act of 1965. He also does the same for fair housing here in 1968. And that's really the important piece that we have here, is that these are legislative victories that are closing the loopholes that are found with legislation. The 1964 Civil Rights Act is really momentous, but the Voting Rights Act and the Fair Housing Act of 65 and 68, respectively, are really helping to solidify that victory. We also saw in 1972 the Title IX of the Education Act in civil rights basically said if you're going to offer a male sport to students, you either have to offer a comparable female sport, or you need to allow females to try out for that sport. And that's really significant even today in terms of civil rights legislation, because we continue to have Title IX as part of our civil rights provisions, in that providing equality of the genders, and when it comes to sports in schools that are funded by the federal government in terms of public education. Now, that wasn't to say that all was forgotten and we didn't have to worry about discrimination anymore. Quite the contrary. You can see the evolution of discrimination that continued to happen. We saw the grandfather clause, the white primary. Now, obviously, the grandfather clause would be declared unconstitutional, as would the white primary. But look at those years, 1915 and 1944. We were talking about Plessy in 1896, and still here we're continuing down this road of discrimination being used in the South. The poll tax not eliminated until 1964, the literacy test in 1965 with the Voting Rights Act, and today this is really key to note that the racial gerrymandering continues. Just last week there was a case in which two Texas congressional districts were declared unconstitutional by the court, and they're sending it back to the legislature to redraw the lines. So this continues even today, which is really important to note, that you can't just let down your guard and say, oh, all is forgotten. We've basically we now have equality. Discrimination continues, and being able to address that is really the key role of the court in determining that constitutionality, or in this case, unconstitutionality. I mentioned the Voting Rights Act. The Voting Rights Act of 1965. It was passed with an expiration. This was renewed in 1982. Not all legislation is. In this case, it was. For instance, the Civil Rights Act of 1964 doesn't have to be renewed. But the Voting Rights Act, because some of the provisions in it were basically calling for pre-clearance, the idea that the Department of Justice would have to clear the congressional districts that are drawn by states. That was Section 4, and that was actually ruled to be unconstitutional by the courts back in 2013, I believe. But other parts of the Voting Rights Act continue, and obviously they will continue now. It was renewed in 2006, so they will continue through 2031. But the idea here was to prevent any type of intimidation or discrimination based on race at the polls, in order to allow voters, minority voters in particular, to be able to vote and not be discriminated against as a result of that. That pre-clearance provision is what I was talking about here in this slide. Shelby County v. Holder was the case, and it basically said Section 4 of the Voting Rights Act was unconstitutional. Now, that means that other provisions of the Act are still ongoing and will be, like I said, through 2031, because it was extended for 25 years. But the idea here was the court was basically saying, discrimination has changed and we don't really need it anymore. Now we know that's not always the case, as we saw with the racial gerrymandering that continues. And this was brought out in the 1993 case Shaw v. Reno, which basically said you can't make a district lines for a congressional district based on race. It can't be the sole factor or even the predominant reason for doing so. Even if it's creating a majority-minority district, that is still unconstitutional. The idea of packing to create the majority-minority district, or cracking to divide up their legislative potential for dominance, is both of those are unconstitutional, according to the Shaw v. Reno case that the court ruled. So that's important to note because of the issues of packing and cracking that we talked about in class. Now, the Civil Rights Act of 1964 went a long way to prevent discrimination in accommodations, in restaurants, in gas stations, movie theaters, all of this based on the Commerce Clause, and the Supreme Court upheld that as being constitutional. It also barred discrimination in employment, and this is really important here because actually what we're hearing now, and we kind of talked about in class, was this Religious Freedom Act that is basically calling for businesses to be able to discriminate against same-sex couples if their religion precludes them from believing in same-sex marriage. This really calls back to the Civil Rights Act of 1964. Now we see here that sexual orientation or same-sex marriage isn't included in that list of non-discrimination accommodations, but it really does beg the question that the courts probably will be taking that issue up if it passes as a national bill, which it has not yet. But if it were to by this Congress and signed by the president or something like that, it has the potential to go to the court. So again, you'd have to find the right case. It's not that the courts are going to legislate that type of thing. They're looking for a case that would address that. But the Indiana law under Governor Mike Pence, now Vice President Mike Pence, is definitely something to note in terms of what potential it could have on the Civil Rights Act of 1964. We talked about the women's suffrage in 1919 with the 19th Amendment. We still see issues with fair pay and gender equity, but the 19th Amendment definitely went a long way towards trying to provide the right to vote for women and striving for equality. There was an ERA Act in the 1970s that was passed by Congress, sent to the states. It was never ratified in the amount of time that was allotted, and so the amendment essentially died. But those rights continue, and the fight for those equality rights continue today. Now, speaking of equality, let's talk equal protection for a moment. The 14th Amendment basically says no state shall deny to any person within its jurisdiction the equal protection of the laws. What we're talking about here, in civil liberties, you'll remember, we talked about the aspect of individual liberties and rights protected by the by the Equal Protection Clause against the government from taking any action against individuals and their freedoms or their civil liberties. This is again precluding government action, but not the individual action, but protecting the group as a whole. So that's where civil rights is really about protected groups and trying to make that distinction between the civil liberties that are protected and the groups that are protected in order to make sure that equal protection is for all. So that's important to note here. Now the court has basically established, and this is probably the most important slide that we'll get to in these highlights, but this is really the standards of scrutiny, and we'll talk about the College Board terms, and then we'll talk about Maggleby's, a couple of Maggleby terms. But the idea here is we're looking at is there a potential for discrimination or some type of differentiation between between what's going on and what is constitutional and what isn't. The court basically says economic matters, there's a rational basis for discrimination. If you are charging more for people who make more money, you are allowed to do that. If you are charging less to people who make less money, you're allowed to do that. You're also allowed, if you wanted to switch those around and add regressive taxes or sales taxes, you have a rational basis for doing so under the Constitution and that equal protection. That's not a violation. Remember, economic individuality is something that we have valued since the founders created the Constitution and ratified the amendments. It is something that that is not an equality issue. We value economic inequality in that if you work very hard and you're entrepreneurial and you're innovative and you create the next iPhone or the next, Microsoft Windows, you have the right, once you pay your fair share to the government, you have the right to keep those millions and billions of dollars. That's really the rational basis the court is talking about here. But when you start to differentiate based on gender, this is more of an intermediate scrutiny, or what Maggleby calls a heightened scrutiny. And this is the idea that there are situations in which you can treat men and women differently, but there's a higher standard here that you have to meet in terms of being allowed to discriminate based on gender. And a great example is the one I used in class for fashion designers, using female models in order to promote female lines of clothing. While using men or women probably would do the job, it's going to be more effective if women are wearing that clothing in terms of trying to appeal to the broader audiences that they are trying to get to buy these products. And that's really where intermediate scrutiny is allowed. It is constitutional based on that. Where it would not be is in terms of if the job is indistinguishable between men and women, and as a result of that indistinguishable position or job description, you're treating women differently than men. That would not be a constitutional under the intermediate scrutiny of the court. And then the last one basically is the highest standard, and this is really based on race, national origin, or religion, and this is the strict scrutiny standard. And this is basically the court saying you really have to have a very specific and there is a minute chance, and by that I mean 99.9% of the time the court is going to say that what you have here is a suspect classification, and you are discriminating based on race. There is a point at which that can take place, but you really got to have a clearly defined reason for doing so. Otherwise, it's discrimination, plain and simple, and it is unconstitutional as a result. And this is where it'll be interesting to see how the courts are ruling on President Trump's second executive order based on the ban on travel to the United States. Because will it pass muster in terms of that strict scrutiny standard? The courts basically ruled in the first one they issued a stay not allowing the order to take place because of that. So it'll be interesting to see how the second order plays out based on that standard. Now, age is not a suspect classification. The whole idea here is there is a legitimate state interest. I mentioned driver's licenses. A 12-year-old can appeal all they want to the Supreme Court to ask for the state to give them a driver's license, but the courts have given a pretty broad leeway to the states in terms of declaring what age at which you can drink, or the age of consent, or getting a driver's license. They've really given and made sure that the states continue to have that right, and there is a level of discrimination based on age in terms of their legitimate state interest, and that is where the court has upheld the states in terms of that role. Now, what they haven't done is allowed age-based discrimination based on gender, and that is where they've struck down those issues. Things like, oh, well, the drinking age is different for women than for men, or the age of adulthood is different for women than for men. All of those have been struck down since the 1970s, and the court has ruled that going back to the idea of intermediate scrutiny or heightened scrutiny is not constitutional. We looked at earlier cases with Plessy and with Brown, so you're familiar with those in terms of the separate but equal is constitutional under Plessy, and it's not separate but equal is not constitutional under Brown, a unanimous decision 58 years later. We also saw in the Loving v. Virginia case, which the new movie that came out on this case is prohibiting interracial marriage. That was deemed to be in 1967 a violation of the 14th Amendment and ruled to be unconstitutional. Then we saw in 1996 the court rules in U.S. v. Virginia that the Virginia Military Institute having a male-only student body admissions process was a violation for women who applied and were denied admission even though they measured up to the same standards as men. The Virginia Military Institute had to admit women based on their admission standards. That rule that they had was deemed to be unconstitutional. I mentioned the Fair Housing Act. 1968 forbid this accommodations in housing, but it also applied to mortgage lending. Unfortunately, there was a lot of mortgage lending abuse that was going on there, and discrimination. Things like steering. Oh, you don't want to buy in that neighborhood. That's a really bad neighborhood. Or, oh, you don't want to get that type of a mortgage. That would really be bad. You really want to go towards this. The courts ruled that to be unconstitutional, and that's important to note here. There's a discriminatory term used in the financial services industry called redlining, and that's where mortgage lenders basically will either charge you a higher interest rate or will not give you a loan because of the neighborhood in which you live. They deem that to be a bad neighborhood. There were many institutions, financial institutions, that actually settled cases with the Department of Justice or ended up paying fines by the Department of Justice suits that basically said they weren't allowed to do that anymore, that was a violation of the Fair Housing Act of 1968 and the Equal Protection Clause of the 14th Amendment. So does it still happen? Sure. And we saw this, in the early 2000s that different financial institutions that are still with us today were maintaining these practices. So discrimination continues, and the hard fight still needs to be fought in terms of trying to make sure that non-discriminatory practices are across the board, not just in housing, but also in mortgage lending and other financial services areas that service the housing industry. The last concept to cover here is de facto segregation versus de jure segregation. De facto segregation is essentially what we have today, which is people basically segregating based on choices that they make, choosing to live in a neighborhood or choosing to shop at certain locations versus the law, de jure segregation, that was basically saying, the law says that you have to segregate this way. So we don't see that. Those have been struck down for the most part since the 50s and 60s. But de facto segregation is what we see today, in that we see a lot more by choice, by the process of who we choose to live with and who we congregate with, and even in selective perception of media or social media for that matter, what news sources we choose to follow, what circles of friends we have in social media. All of those things contribute to the de facto segregation that we see today, and overcoming that is a continual process. But the legal separation, the separate but equal factor, did end with Brown, but like I said, the de facto segregation continues. And then that's what stems over into things like the redlining and the steering and the mortgage lending issues that we see. The the quote from President Johnson was what I talked about in class about equity versus equality. He said, "Freedom is not enough. You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, you're free to compete with all the others and still justly believe you've been completely fair." This is the example I gave of the lamb, the sheep or goat that I have on the farm that gives birth to twins, and the mother decides she only has enough milk for one of them, so she picks one and leaves the other one behind. To go out there and say, "Oh, hey, you both have a fresh start. Go, and good luck with you," is just contributing to one's death at that point. That's where I basically will bottle feed and tube the baby that is ill and malnourished, and basically try and provide the nutrients and the resources that the mother normally would in order to give them a fair shake. That's the idea of equity, and that's what President Johnson is talking about here. Equality is the idea that we all start from the same starting line. But as President Johnson said, you can't assume that everybody's on the same playing field just because they're starting at the same line. That's where the equity comes in, and that's the important piece. And that's why many times I bring the goat or the lamb into the kitchen or the garage and bottle feed them and get them well before you put them with the rest of the herd. And that's what they're talking about there, and that's what President Johnson is referring to. Now, the affirmative action, the reverse discrimination case is the Bakke v. Davis, the University of California at Davis situation, in which Bakke was saying he was the victim of reverse discrimination. He was white, and the university ruled, even though he had higher test scores than those that were of a minority, they were given admission because they were trying to fill quotas. And the Supreme Court ruled that quotas in this situation violated Bakke's equal protection, and ruled that race essentially can be a factor but not the factor in college admissions as part of their affirmative action practices. So it really said that reverse discrimination wasn't a good thing either. You couldn't use quotas in so doing, but you really had to focus on a holistic set of factors in which race was one of those factors, but not the factor that was the determinant. In the Michigan cases of Gratz and Grutter, here we see in the undergrad case that people can choose in terms of de facto segregation. They can choose to attend here or not, and race could be a factor, but again, not the factor. In Grutter, they said, you know what, the law school is trying to promote diversity. De jure segregation in terms of trying to pick more individuals that are a part of the student body that are minorities is allowed under the law. So in the law school, they said because the student body of the law school is much smaller, they're trying to pick, in order to promote diversity, they're trying to pick more minorities to be a part of that diverse law school society, and that the Supreme Court ruled is allowed. It's in undergrad where people are basically choosing where to go to school, and there are thousands of people. That's where it is not allowed. It can be a factor, but again, not the overwhelming factor in the case. I hope that you found these helpful. Good luck with Chapter 16, the upcoming quiz, test, and the AP exam. Live the 5. I hope you're living the 5. Hashtag living the 5.